Blair. Now, it's interesting because when we actually looked at this Section 59 of the Police Reform Act, it says there very specifically that this can only be used if Section 60 is in force. So what's Section 60? So we went onto the legislation website and we looked at Section 59 and then we skipped to Section 60. Now, Section 60 says that basically the Home Secretary, who at the moment is that horrible woman Shabana Mahmood, the pro-Palestine Islamist Home Secretary, if her blessing, they call it regulations, that's legal talk for basically her decision, her blessing. So if Section 60 is enforced, then Section 59, you could seize the vehicle. So the police, in my opinion, they had to send this, and this is probably another reason why they kept us for 3 hours in Altrincham.
Right, so basically, right, Paul's just explained sort of more details about this, right? Now, I've looked at this act here, right, and even though he's saying that it's got this other section which applies to the Home Secretary, right, he's still missing the whole entire point of the law itself, right? He's missing the entire point of the law itself, right? That Home Secretary part only applies, right, in a normal event, in a normal offence, in a normal instance. And what I mean by that is that Police Reform Act 2002, vehicles used in the manner causing distress or alarm or annoyance, like you said, boy races and things like that, right? Vehicles used in the manner causing alarm, distress or annoyance, right? And it says, right, where a constable in uniform has reasonable grounds for believing that a motor vehicle is being used on any occasion in a manner which is, and in B it says, is causing or is likely to cause alarm, distress, annoyance to members of the public, right? Now, this is the thing. That goes for 99.99% of the citizens going about their normal, everyday life, right? So, you know, normal people doing normal things, like if you're going to a football match, you know, and you said Gary Neville is an idiot or something on the side of the van or whatever it is, right? It's only in a normal, that's common law, right? Now, that means that you can go to the Home Secretary and so forth under the common law. But this is the thing. You're going to the other end of the stick, right? Come back to the other end of the stick from the Home Secretary, back to where the incident arises, right? And you need to already know when you're a political party and you're engaged in political processes, there's already certain other laws and legislation that apply and are in effect, which on this occasion have been completely and totally disregarded, right? And this is why it's important. This legislation here, right? This legislation is saying that when a constable in uniform, right? So this has got nothing to do with the Secretary of State, right? At all, whatsoever. This is purely the initiative, opinion, reasoning, right? And observations of a constable in uniform, right? That's a human being, a thinking, deliberating human being, right? When that constable has reasonable grounds, then you have to get the dictionary out and not be brain fogged to know what reasonable means. That is that the constable has to be able to give reason, right? To be able to give a reason, or he has to have the ability to be able to reason with you, right? You're being accused. This is why you've got the right to remain silent, but anything you say can or will be used in a court of law, right? You then, when the constable is reasoning, and it's reason able, right? He's able to reason. If you give any legal effect, law, legislation, or right, which prevents him from being able to reason that, right? And note, it does not say when a constable in uniform has legal grounds or lawful grounds. It says reasonable. That means it is purely subjective, right? He's able to reason, because here it says whether it is cause alarm, distress, or annoyance. There are three things: alarm, distress, or annoyance, right? He has to be able to reason that there are grounds for it able to be cause alarm, distress, or annoyance to the public, right? Now, this is the thing. It says to members of the public, right? Doesn't say a section of the public or all of the public or whatever, right? Now, this is the thing. Alarm, distress, or annoyance. Now, this is the thing, right? It doesn't say that a constable has lawful grounds. It says reasonable. So, this itself is legislation. It's law. But the law says he has to be able to reason. Now, that means that when you raise a right, okay, or a law which says that you can do that or it can be done, it is lawful, then he cannot give reasonable grounds for believing, right, that it can cause alarm, distress, or annoyance in law, right? Now, this is the thing. Now, the Obscene Publications Act says that if it is for the public good, right, it's not an offence, right? It's not obscene. So the effects of it are not legally, there is no obscenity in law, right? There is no effect, even if it's obscene, or it might otherwise be obscene, right? If you're using it for a purpose of the public good, it's not legally capable in law. Legally capable in law, right? It's not legally capable in law. So, this is the thing. Let's go back to the wording on the 2002 Act, right? It says where a constable in uniform has reasonable grounds, not lawful grounds, right? The constable, it doesn't say that constable has to have lawful grounds, right? It only says with reason. But when you have got a lawful, right, a piece of legislation, right, or a right, then this does not apply because it's common. This is common law. And this is like in the Bankruptcy Act, you know, where it says that in this act you are not allowed to use privilege of parliament, right? You're not allowed to use parliamentary privilege for criminal charges in the act, but not in other acts. It has to say in an act that you can't use parliamentary privilege. Well, election campaigns for political parties are privileged of parliament, right? And then you've got, it's an advertisement in Class F because you're using the 1688 Bill of Rights, okay? And that says that all prosecutions are illegal against you. And in fact, a contempt, because you can use any act. In the control of advertisements, you apply Class E and F to the material, and it states there, in that act, you can use any act. There are a few acts that say you can use any act, right? So when you are looking at an advertisement, right, you are allowed to use any other act of law, and it depends on what the advertisement is for. Now, you know it's for electoral processes and petitioning, right? The public. Now, that's where you use the 1688 Bill of Rights right to petition, that all prosecutions against you are illegal. That's what protects you. In fact, it makes the police into the offender. Now, this is the thing, right? When they are saying, you know, he's likely to cause alarm, distress, annoyance to the public, right? This is a prosecution and offence, but that's illegal. It's illegal for the police to do that prosecution or offence. It's not lawful because it's Class E and F material for elections and petitions, right? Now, every time the police use the Police Reform Act, Section 59, right, it might not be an advertisement. It might not be an electoral campaign. It could be anything. It's just that the vehicle is being used on an occasion in a manner which might cause alarm, distress to members of the public, right, which could be being driven in a certain way. It could be being driven erratically or revving it or things like that. What the police are actually doing is they're focusing on the advertisement part which is attached to the vehicle, right? And it's the advertisement part which is attached to the vehicle. It's not the use of the vehicle itself. It's actually the advertisement on the vehicle. So they're completely and totally trying to use pure poetic license to get this charge on you, right? When they don't even... It's actually not the vehicle that is being used, it's actually the advertisement. If you say, well, this is when you come into the reasoning of it. When a constable in uniform has reasonable grounds, well, he's trying to reason with you, right? He's trying to reason with you that it is causing alarm or distress and it's the vehicle that's doing it. So this is where you have to use intelligence and intuition and knowledge to say, officer, the vehicle is not being used in a way which is annoying the public, right? The advertisement, you think that the advertisement on the vehicle is might cause annoyance to the members of the public, but I can tell you that this advertisement is for an electoral campaign. It's Class C under the Control of Advertisement 2007, and we're trying to get public support in a governmental process. It's exempt from obscene publications, so that's one example of how its effects are annulled legally, so you can't say that it's causing obscenity to the public, right? Because I've got members of the public supporting my campaign. It's a public-supported campaign, which means it's for the public good or a section of the public, right? And that is why these acts are made. And then, it's very long-established law, that, right? You say, I'm using any act of law. For this advertisement, I can use any act of law in Class F. And you say, I have declared to you that I'm a political campaign, and you've checked that it's not prescribed. So we can identify that it's Class E material. And also, we're trying to get the public to support my campaign to get people into Parliament, right, and oppose members of Parliament. I am using the 1688 Bill of Rights, right to petition. On this advertisement, I can use any act of law, and you know that it's a political cause, and all prosecutions are illegal by Article 5 of the Bill of Rights. And in fact, if you continue to pursue this prosecution, you are committing a criminal offence against me. I am a victim, and I can rely on that right in any proceedings, including these proceedings now, which you're attempting to bring against me through 2005 overriding objectives of the criminal procedure rules, right? And you've got to recognise that now. And if you fail to recognise that now, you're committing an offence, right? This is the thing. And they're committing the offence is a contempt of Parliament. And that Bill of Rights, it's a statutory power in law. And I wouldn't mind, but whenever you're doing something for the campaign, you've got a legal right to use that act because you are doing something for the campaign, even if an act of law doesn't say that you can use it or doesn't say that it's in effect. It has to say that you cannot use it in an act. Like the Bankruptcy Act, it says that you cannot use privilege of Parliament to protect you from criminal proceedings. In this act, right, there is no such clause in this Police Reform Act 2002, right? And the control of advertisements, which applies to the definition of what an advertisement is in the 1990 Town and Country Planning Act, right? Which is any word, letter, sign, representation or whatever, right? That's how you identify it's an advertisement, even an illuminated display. Now, either the police aren't taught the control of advertisements in the police college or they're ignoring it. It's mainly an act which the local councils use because the local councils are the one who usually fine people, right? It's not usually using criminal law because it actually, defacement on the surface is put into fines only and you don't bring a criminal charge, it's a fine. Now, the police don't like that because they do not have any criminal charges to bring under the control of advertisements. The council give fines and the council have got to remove things, right? But the police just like to throw these acts that they've been given and this law that they go around policing in normal instances against regular citizens in normal events under a private crime by a private individual, right? Not a public cause. And they think they can just use these charges. They can't actually just use them when they want. It's like, they've got these tools they use and they're very comfortable with these tools and they're familiar with them and like these laws. And it's like old trusty, you got your old trusty, your old trusty tool, right? And it's comfortable and you might be able to use it a multi-tool and you like using it for different jobs. But here it says, do not do this, do not use that. But the copper likes using it, is comfortable with using it, he's got confidence using it. Why shouldn't he use it? It's his old trusty law, his old trusty truncheon, right? This is specific law which says old trusty can't be used, right? Old comfort tool can't be used. It's an offence because it's like in a doctor's surgery, right? You've got specific intricate tools for specialist jobs, specialist laws to do specialist things, right? And when Bobby comes along with his truncheon, right, he's not going to fix a problem by bashing somebody on the head with it, right? When it's an intricate thing. This is specialist law for political causes. Now, the government are refusing to help clarify this because it's true that a lot of them aren't qualified and they don't really properly understand it properly, even in the Privileges Committee reports. And that's why we've got Mike Amesbury, Dan Norris and Patrick Spence getting arrested when they shouldn't be. So the police are overstepping the mark. Now, when the police are doing this a lot and widespread, they're actually acting unlawfully as an organisation. Now, if we were doing that and acting unlawfully against the government, not using the law and acting lawfully, they'd say they were going to prescribe us. Yet, they're not going to prescribe the police. So the government is institutionally corrupt because the Secretary of State for Policing or the Minister of Policing, right, Dame Diana Johnson, and this, Home Secretary, they aren't really legally qualified to know what they're doing. And if those police would have identified properly that it was a political campaigning cause and reiterated it properly, and you would have given reason for it all, then the Home Secretary wouldn't have been able to stand back and not do anything. But you don't need her to give consent or not. That's the other end of the stick. It's arising out of the police officer's own mind, initiative, reasonability, right? So if he says it, he thinks he can do it, right? But he thinks he's been a good little police officer and going about the law. But he's not, because he doesn't know the law. And this is when you've got to tell him the law, like Fiona Rose Diamond was doing the other day, right? This is an advertisement on the side of a vehicle. You're trying to say the vehicle is being used in a way which is causing alarm, distress, right, or anxiety. But actually, you're misconstruing the truth, officer. The advertisement on the vehicle you believe is causing distress, anxiety, or annoyance. And I can tell you that advertisements, particularly in Class E and F, we are using the 1688 Bill of Rights right to petition, and all prosecutions are illegal. And there are acts that are made to be compatible with that. That's why the control of advertisement says you can use any act in E&F. Because if it's an election campaign or petition, you need to use that act to protect it, right? That's what we're doing. And the Obscene Publications Acts and many other acts have a compatibility with that. That's why there's a public good. Why? Because public supported causes are for the good of a section of the public who support it, right? But you don't need that. That exists because of the 1688 Bill of Rights if it's political, right? Because it's a public, why would it say public good? Because it's not a private offence or crime if it's for or on behalf of members of the public. And this is a problem. I actually complained to professional standards about it, right? And they sent me a letter, but I haven't got around to reading it yet. I don't actually want to read it because they're just trying to fob you off. They've tried to fob us off. So I'm actually going to submit this statement to them, right? I'm going to submit this statement to the police because they're just... This is the thing, right? This is contempt by the police, and they don't want actually to be liable because they've actually been doing it so extensively and widely. The police need prescribing. What do you do when the police are acting as terrorists and acting beyond the law, suppressing political campaigns that are going to be protected, and they've got multiple cases? Do you think that the police are just going to put their hand up, right? Oh, yeah, we reported ourselves in to the police standards. We reported ourselves in. They're not going to report themselves in because they actually don't want to confess and admit this, because there were multiple police forces who have violated it and broken it. Keir Starmer was in charge of the CPS and now he's Prime Minister, right? And the police chiefs, they're fighting this. They're fighting it as a terrorist organisation against the public's constitutional rights. The police are the terror organisation. When will the Secretary of State Policing prescribe the police as a terrorist organisation, right? Until they cease to do this. And all officers are issued letters, right? They're issued notices and letters, and the police college training is updated, and all of the police officers who have violated this up to this point need legal action taken against them, contempt. But it's not done by the courts because it's not under the jurisdiction of the courts. The contempt's Parliament. Now, this is where you've got the Home Office and Shabana Mahmood and Secretary of State for Policing and Ministers of the Home Office and Policing. They've got to issue contempt with the Attorney General. That's why you need to get the other end of the stick. When are they going to bring contempt against Manchester Police and give Paul Golding his money back and injury and compensation for his entire day being wasted, right? Now, if it's Labour MPs and Labour ministers, and if the campaign was opposing Labour, it seems to me that those ministers might not be in an impartial position or an unbiased position in order to take legal action against the police. In fact, they don't want to, which means we've got Parliament members, ministers and MPs who are breaking the Constitution, treason against the people, contempt. And they can't be held to any account in a court out of Parliament, so they keep saying, by their Article 9. Now, the only way to get action against them is by petition and to get them in front of a committee in Parliament. But they're even blocking that on e-petitions, right? They don't want it on there. They don't want us to collect signatures. So they're blocking redress. They've hijacked Parliament and they're holding us to ransom using the police as a militarised organisation illegally, right? That means that we need Parliament to have Dame Diana Johnson and Shabana Mahmood in front of a committee under contempt and treason. If they do not stop the police from doing this and get the Attorney General to bring contempt charges against the police force, and the outrage of the public for that would be immense. So they're not going to do it. We're being hijacked by fascists, right? Dame Diana Johnson and Keir Starmer and the Labour Party have they're hijacked our government. They're hijacking it now illegally. They're in that Parliament and they're using our money. It's our money and our police force against us because they won't tell the truth about the law. And they're even sacrificing their own members like Mike Amesbury, Dan Norris and Patrick Spence. They won't support them because they're throwing the right. They're even committing kamikaze to drop a few members so they can make it look like the police are acting lawfully when they're not. They're sacrificing their own party members because Mike Amesbury he either is stupid and can't do his own law, right? Or he's doing it on purpose as a sacrifice. And this needs to stop.